My name's Bill Rafter. I'm with the National Center for State Courts. I just celebrated my 20th anniversary on July 1st. Thank you. The critical component, and the reason why I felt so tied into a lot of what Ernie Friesen was doing back 40 years ago is Friesen, and we'll talk a little bit about this, was coming at this from what was described with a somewhat pejorative sense, the academic. You'll see when we talk a little bit about the practitioner. Myself, my background is I never worked for a court. I worked as a paralegal for law firms for several years, thought I wanted to be a lawyer. Looked behind the counter at New York State Supreme Court, saw a NACM sign, NACM certificate, and I said, I don't want to do what the lawyers are doing. I want to do what's going on the other side of the desk. 3 a.m. legal briefs are just not throwing to me. That became a master's in court administration under John Jay, which then circulated to a position at the National Center in the research division. So I went right from my master's into research. Richard Schaufler, Court Statistics Project. I see some friends and no foes, but I see friends and family. And that turned into, about 5 years later, knowledge management, which for those of you who, the serious answer to what is knowledge management is if you call up the National Center and say, how many courts are there in the United States? How many drug courts are there? What is the standard for bulletproofing a dais at a courthouse? I know, or I know the people who know. That's the abbreviated version. We are the information clearinghouse. If I don't know it, I know who knows it. And so I'm calling Kevin Bowling. I'm calling people on my staff. I'm trying to put you in connection with the knowledge. Because of that, we have access to archival information. And today, I'm looking at the 40th anniversary of NACM, and I'm looking at first principles. I'm coming at this from the academic's perspective. I'm looking at, my guesstimate here is probably, don't feel too bad about this, nearly 1,000 years of court experience here. Think about it. I've got about 40 people in this room. If each one of you is somewhere, plus online, if each of you has about 60 people, 10 to 15 years of experience, I'm looking at somewhere between 600 and 1,000 years of collective court management experience here. I'm not going to tell you anything about court management you don't already know or live or breathe. What I'm going to ask is, let's go back to first principles. What are we doing here? What is court management? What is court administration? And where can we take it in the next 40 years? All in an hour and 15 minutes. I know. I give myself the hard assignments. So we're going to talk about the NACM core. We're going to talk about Friesen's original text. Who here's ever gone through ICM or CEDP or in any familiarity with Friesen's or 8 purposes and responsibilities of courts? Guess what I'm not going to post at all in this entire slideshow? Because we're going back to first principles. I'm not going to show you the 8 purposes and responsibilities of courts. Okay, you already seen it. You've been exposed to it. You're not tabula rasa, to borrow the blank slates. But we're going to try and look at it. We're going to put Friesen in context. Not our context. Not in the context of the NACM core or the predecessor to the NACM core, but in 1981. We're going to reestablish the context for today. And we're going to ask some basic fundamental questions. We're going to review and revise. Yes, it's not a sacred text. We can, in fact, review and revise. I'll give you a hint. It's been reviewed and revised. Friesen's original, what we have today is a revision of a revision of a revision. And finally, we're going to have some takeaways, which isn't English for takeaway food, but. So let's start, because otherwise Jude will be mad at me. Core Champion Achievement Program. Who's here working on the Core Champion Program? Yes. Awesome. Raise a hand. Raise a hand. Good. Always be learning. Somebody I have a PhD in court management. I literally wrote my dissertation on unification and efficiency of court systems. Always be learning. If you think you're the smartest person in the room, go to another room. You're not, or you shouldn't be. This is a wonderful interactive program. If you're not doing it, you should be. Here's my plug. We look at the 13 core competencies. Again, these competencies are divided into 3 main modules: vision, principle, and practice. okay? This is the third generation of this, and it improves every time I've seen it. I've been around now, NACM, 21 years. And it improves every time I see it. So you're gonna take one thing from leadership, one thing from public trust and confidence, one thing from, let's say, caseflow management, okay? You're going to then look at that. It strengthens you as a core professional. It exposes you to the core curriculum. Why do we have this? Because, again, the 600, the 1,000 years of collective experience and more in this room says this is what it takes to be a modern court manager. And then we're going to recognize attendance through certificates. Yay. I like bling. Bling is good. Positive affirmations. It's on an honor system now, okay? It's on your honor that you've been here or are streaming. Hi, streaming friends. You're going to answer 2 questions at the end of this. They're called SRT questions. You've got to answer them. I came up with them, so again, don't blame Jude. It's on me if they're horrible. But the idea is, what did you get out of this? What are you trying to find out about this? One competency from each module. I mentioned the 3. I would have just picked caseflow management out of the first one, but what have you. All competencies with the principal module, all competencies. So you got levels. You want to be an explorer. Great. 1 from each. You want to elevate up the hill. Great. And then champion all 13 competencies. This is a feedback loop because you can't possibly get all 13. You got to keep coming to NACM. You got to keep having these fun experiences. Attend or view a qualified session, what you're doing. Complete the structured response form for each curriculum you attend. That's the SRT, right? If you go into the app, and hi, streaming friends, it's on your app too, there's a thing all the way at the bottom that says SRT. That's that structure. What do you want to do with it now? You want to write an article. I say this as the former editor for Judicature and a bunch of other things, Justice System Journal. You want to write an article? Yes, you do. You receive reward and recognition. You receive possible publication. And finally, again, recognition. There's going to be recognition. There's pins, there's papers, there's ribbons, there's documents, all kinds of other stuff. Potentially, you could be up here doing a presentation as well. Shiny. How did we get here? Let's start with Friesen's text. If everybody could take a look at that QR code, yes, it's from Google. That's why it has the dinosaur. Please bear with me. It's not because I'm that old. Oh, my heavens. Where did we come from? The first National Symposium on Court Management was sponsored by, not NACM. Anybody know why it wasn't NACM? Didn't exist. It was by its 2 predecessor organizations plus CCJ, COSCA, National Probate. No, it was a cast of characters. But it wasn't NACM. But this conversation led in part to NACM, this first National Symposium. The question, Friesen, it would later come out, the symposium would come out as articles. Again, if you see a presentation, make it into an article. Court managers, magnificently successful or merely surviving. This was not Ernie Friesen. For those of you who don't know, Ernie Friesen came at this from, he was an attorney, he was the president of the National Judicial College, he was the director of the United States Administrative Office of the Courts. So he's coming at this in 1981 from the perspective of somebody who was a lawyer, who was well-versed in the legal vernacular, who was well-versed in the federal system, and had been focused a lot on judges, National Judicial College. He was among the first generation of what we call court management. He also had the advantage of coming from the federal system. Why? USAOC had already existed. Interesting tidbit. Little trivia. Here's knowledge management. Everybody remembers the court packing bill, right? FDR, the court packing bill, right? And FDR's argument was, well, we just want efficiency, right? And these old judges are too inefficient. You know what? So the first 2 parts of that bill were, judges over the age of 70, you add 1 more justice to the Supreme Court, and then we reconfigured the Supreme Court. You know what Section 3 was? The creation of the modern U.S. Administrative Office of the Courts. Because he said efficiency. So when the bill failed, the Chief Justice at the time, the U.S. Supreme Court, went back to Roosevelt and said, great, we want that. You give us court management now. You signed up for it, you agreed to it. So Friesen's coming at this from 60 years of experience in the federal courts. Court administration in 1981 was still in its infancy. We didn't know what we didn't know. So they had a debate. You had Friesen and you had Harrell, who was actually the administrative director of the courts in Rhode Island, AOC, RI. The debate format said this. We're going to ask 2 questions. Number 1, Are court managers serving a perceived and defined role? Number 2, whether court managers have improved the efficiency and fairness of our judicial systems. Ernie, much to his credit, then proceeded to ignore those questions. You go look at the transcript, look at that QR code. He proceeded to ignore the questions. Harrell called him out on it. Jeff Gallis, who wrote what amounted to the executive synopsis, called him out on it because Ernie looked at it in much to say this, these are not the questions we should be asking. We'll get there. Those 2 questions, we'll get there. But right now, we have to look at what is court management in 1981, and the answer was, and according to Friesen, survivors. This was not a profession yet. This was survivors. After, we'll go over that, what that looked like. In 1981, you had people who, the profession had kind of been created. You had clerks, you had trial court administrators, but basically they were just trying to push paper. There was no grand division. So asking this question about, are you perceived and defined role, there was no perceived defined role. They were making it up. Number 2, is it improving efficiency? Actually, Friesen points some articles that no, it probably didn't initially, but that's okay because in your infancy, you don't know what you're doing and you don't have the tools yet. Harrell was the one actually arguing that court managers are doing more than just surviving and we're doing fine. Okay, he's coming at this from the practitioner's perspective, right? He was somebody who worked in the court administrator's office and as a trial court and all these other things. He's saying, no, Ernie, you're wrong. We're doing better than this. We're not just bean counters. We're not just surviving. We're doing more than that. Guess who won the debate? When they did a survey afterwards, guess who won the initial debate in 1981? Keep in mind, the people in that room were also court administrators. Ernie won. I'll get to that in a second. They agreed. What was his original 5? Again, look at the text. You can look at that at the dinosaur code. To do justice in individual cases, or even better, to do individual justice in individual cases. Doesn't sound that far off. Number 2, there must be the appearance of justice. Again, notice these are quotes. These are verbatim. Number 3, having a way to resolve disputes amicably or at least without a fight. There was a presentation from our friends in the Virginia Office of Executive Secretary yesterday about purposes and responsibilities. It was a wonderful presentation. I loved it to death. The one thing that they minimally glossed over was this particular point, which we now talk about fair and impartial. Ernie meant physical violence. And I don't think we fully appreciate this, having hundreds of years of common law. Why do the courts exist? One of them is because the alternative is we shoot people in the streets and we beat them up. He meant it at a physical base, Maslow's hierarchy of needs. If you don't provide a court forum for people to resolve their disputes, they're gonna take it out on themselves and others. We don't think in those terms, at least I hope we don't. We don't think in those terms, but Ernie was trying to get the academic. Let's get down to base principles here. We have courts so that we don't beat people in the streets. A formal record of legal status, and to protect individuals from the arbitrary use of government power. Ernie's coming at this from an academic. You know where this phrase came from? It wasn't Ernie's. Jeff Gallis wrote it in Justice System Journal 5 years prior. There was an article he wrote where they were trying to, again, cobble together. He was talking about something about court responsibilities. So you could see Ernie's trying to pull things from disparate sources at this time because there was no template. Ernie's building the template, okay? But look at the language. Now let me come back to you. For those of you who do know purposes and responsibilities of courts, how far off is this from what we have today? It's pretty close, okay? But it's evolved. Again, beat people in the streets amicably? No, we use nicer terms like now, impartial form, right? Formal legal status. But here's Friesen's question. Why do we have courts in the first place? First principles. What is the movement by which we can measure their efficiency? If I can't tell you why you exist, I can't tell you if you're doing it efficiently. make it a little bit personal for a second. I was doing my PhD on court management and efficiency, and I was working with somebody in the Virginia Commonwealth University Public Affairs Division. Oh, Bill, I'm not a lawyer. I don't know anything about law. I'm like, I don't care if you know about law. I'm not asking for a lawyer. You are a statistician in public administration. Can you tell me? I said, I can tell you an incredibly efficient court system. Every civil plaintiff is wrong, and every criminal defendant is guilty. That is an incredibly efficient system. We fail 3 of these. Maybe a 4th. I would say, you definitely have a formal record of legal status. You're guilty, you're wrong. So we're looking for more than that. And Ernie's coming at this in base first principles. And are we getting anywhere? Again, Harala is arguing, no, we already got there. We're fine, we got there. Ernie's saying, hold on for a second. Again, this is the first generation of state or local court managers. Ed Gallus, it was mentioned earlier. David Slayton, again, Los Angeles. We always have these LA connections. LA connection, it's not what I meant by that, LA connection, but connections to the history. Was a trial, 1957. 1957, 25 years-ish, and they're still trying to understand where are we doing. Ed Gallus, Nesta Gallus, Carl Barr, names that hopefully some of you know, and hopefully some of you don't because they're in the past, but you should know them. Why you are here is because of people whose names you will not know. I urge you and encourage you to look at the original texts to understand why we do some of the things we do today. Ed Gallus is 1957. Surely it's been 20 years. Surely we got this thing down by now, right? No, the profession hadn't existed yet. NACM was the first, again, the two combining. And then we still have this debate. Is court management simply going to be lawyers leading lawyers led by judges? There was a strong argument that says, again, you saw in the ABA, you saw that in the creation of used to be the big 3, right? University of Denver, American University, there's public administration that's going to take care of this. There was another undercurrent that said, no, the ABA, the law schools are going to take care of court administration for us. You're laughing, but that was a legitimate thing. We're going to train lawyers to be managers in law school. It didn't make it. But in 1981, it was still a debatable proposition. I see some people who are like, but it was part of the debate. So, Friesen is arguing, look at the title, Court Managers Merely Surviving. And where's he slugged out of? He's not slugged out of USAOC director. He's not slugged out of National Judicial College. He's coming at this again from the perspective of a law professor, that academic perspective. They're survivors. Most attendees after the post-debate survey agreed with Friesen. In 1981, court administration was merely survivors. And I like this quote. I think I've always had the feeling that this business of court administration was a little shaky because there was the fear. The fear was the lawyers are going to come in and just take everything over, or the judges were not going to have any degree of respect and we're just simply going to roll over the staff. I encourage you to read the full article where Ernie goes into are you doing what you should be doing? Or are you doing just what it's going to take to keep the judge happy? Or to keep the judges at bay would be another way of phrasing that. Would it survive into the next decade? The answer at that point was yes. Everybody kind of came away, yeah, court administration in some form or fashion was going to survive from 81 to 91. But what was it going to look like, and what is society trying to address? Again, first principles. Why do we have why do we have courts, and then why do we have court administration? Again, we had, if you go back to Wessex, we had over 1,000 years of court systems without court administration. At least what we understand as court administration. We had apparatchiks, to borrow a more Russian term. We had clerks. But what did we mean when we said court administration? Still in its infancy in the United States. So then, we've got Friesen's 5, which is an awesome name for a band, but it's not what I'm talking about here. We have Friesen's original 5, but then 8 years later, we have trial court performance standards, some of the people in this room were integral parts of TCPS, but we're going to take Friesen's 5. So they took Friesen's original 5, but said, okay, well, we're going to include the following: uphold federal and state constitutions, working independently but in cooperation with other branches of government, promoting the rule of law, and encouraging behavior in accordance with societal norms as expressed in statutes, ordinances, regulations, blah, blah, blah. What does this mean? It means it's still up for debate. Friesen's 8 is not locked in. There is still a dialogue happening 10 years later. Now, 10 years later, court administration survived. It thrived. It grew, it developed. But there's still no lock-in on what it means to be purposes and responsibilities of courts. TCPS comes out with this. Okay, reasonable, rational, logical. Now we get into what became the additional three. And again, this is an evolutionary process. If you look at the literature, sometime probably around TCPS in 89, if not 87, you start to see Ernie's writings and that of Nacum and others start to come out with these three. Not quite this language, but very close. Deter criminal behavior, rehabilitate persons convicted of a crime, and separate some convicted people from society. From Friesen's 5, we're now adding 3 more, but what do these 3 things all have in common? Crime. Who here works a civil docket? Who here works a domestic relations docket? Juvenile. The juvenile dependency, not delinquency. Ordinance, civil violations, civil traffic. Of the 8, 3 of the 8 have ceded territory to criminal. This has ramifications. It has ramifications throughout the next 40 years, 30 years at that point, because of the nature of it. I'm not arguing against it. I'm not arguing for it. I'm asking you to understand where it came from and why it is and the ramifications it has. So then we come back. The recession did things. It did things because it forced people to understand and reorganize what is the core function of courts. It's a different, entirely reestablished the conversation. Gene Flango came out with some things, Ken Batty came out with some things, but basically saying, look, we've got years of experience now, we've got problem-solving courts, we've got alternative dispute resolution, we've got all of these. We need to, Kent's argument is, we need to expand the list. Gene's argument was, in paraphrase, no, the list is fine, but we need to reformulate the language, which again, had already been reformulated 3 times previously, so, twice before, so what's a 3rd time? But it's still an open dialogue. Again, here's those QR codes. I recommend you look at them. Don't look at them now because they need the time and attention to read through and focus. They really do. They're both great, fantastic pieces of literature. And really set the tone post-recession, I would say. Even though they were 10 years later, you see that sort of, Gene talked about repurposing courts, right? So let's reestablish that context. Newsflash, it is not 1981. Court administration, hopefully, I could say, going out on a limb here, is no longer shaky. So you don't have this survival instinct. There isn't a, oh my goodness, we're not going to be here in 10 years. The lawyers are going to come in and the law schools. And At this point, again, 81, the conversation had pretty much ended, but it was on the back of people who said, no, court management is out of its infancy. It's not shaky anymore. So what do we do with these things? What do we do with these purposes and responsibilities of courts? Well, the first thing we're going to do is we're going to deconstruct them. I want everybody to pull out your phones. And for those of you online, if you could go to the link, we're going to do a review. Again, hundreds of years of collective wisdom in court management in this room. I want everybody to go in and review Friesen's original 5. And let me know when you have that, because then I'm going to bring up the results in a few minutes. Do, 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 do. And if there's any streaming friends, please know if you put questions into the question box, we will have somebody reach out or relay that information. So. I can remember doing presentations like this where everybody would get a little red sticker and you'd walk up to whiteboards, and technology is a wonderful thing. Yeah, the whiteboards, put your sticker up on the whiteboard. There's something to be said for the mechanics behind the mechanical act of physically showing everybody how you vote, but then I appreciate the privacy. And again, it's okay if you disagree with Friesen's 5. Again, I want that band name. Does everybody have good clearance on the QR code? So I'm going to go. I could not figure out a way to officially embed this thing in. So let's go take a look. So, first one, to do justice in individual cases, or even better, to do individual justice in individual cases. 78% of you said keep, 22% of you said keep with slight modification. NACM effectively opted for the second one, right? We don't have, again, this is apparent that this is almost a side clause, to do, or even better, to do individual justice. We have that. That is effectively what the original is. Why is that? Why does that have such overwhelming support? Does anybody want to volunteer, or I'll tap you on your shoulder? Why did this succeed? Why did you vote that way? Brave soul. I've got 3 brave souls. Yep, you got that one, Kelly? Thank you. Yeah, I gotta stay up here.
I think if people don't, on their own, feel that they got justice, then nobody's going to feel that there's any justice around. So you have to have that belief that, okay, they listened to me and I didn't win, but they did listen to me. I had my chance.
I want to pick up on that word, believe. Actually, we get to that in a second. It's the perception of justice. This is to do justice, right? And it's 2 components, right? To actually do justice and to be perceived of doing justice. To borrow from our ethics friends, the appearance of impropriety and the actual impropriety are 2 separate things, but they're both critical to understanding ethics in that case. Yeah.
So my answer is a little bit more simple. I'm newer to the sector, 5 years, and so I've taken ACM and ACE, and this is definitely a message that I've heard over and over again. But beyond that, I got into this sector to help the community, and that's how I feel every day when I'm doing work.
Right. Good. That's the calling perspective, right? It's not a career, it's not a job, it's a calling. Okay, so that's that moral, that sort of sense of self, reaching out to community. Who else?
I voted that way because I think doing justice is our core responsibility.
Okay, why is it our core responsibility?
Well, that's why we exist.
Yeah. Yeah. There you go.
That's why we exist, is to do justice.
Yeah, and I agree with that perspective. I mean, of the purposes of courts, I mean, this is a fundamental element of the rule of law. I mean, at its root, it's all about the rule of law, and this is an essential element.
Right.
So Tom Tyler did research about procedural fairness and found out that the enforceability of an action depends greatly on whether a person felt like they had justice done to themselves individually, and whether they were heard.
Right.
And so that's I think there's even data to back up that this is a good thing.
Right. Okay.
I think some of that last remark also bears on the second more perhaps than the first. Doing the individual justice in the individual cases to distinguish the fact that you're not treating every case as if it's an identical widget. Each case is dealt with on its own facts and applying the law to those facts. And that's critical to the aspect of what we think of as justice.
Yes. By the way, for my streaming friends, we're having a little bit of technical issues here, so I'm swapping at it, trying to convince it needs to behave. I'm not doing justice to it, but it's. So I'm hearing a lot about doing justice and the appearance of doing justice, which are good and important. But then I'm going to go to the next element, which is the appearance. And this is why, again, I appreciate your perspectives and what you said, but Ernie divided the two. procedural fairness and procedural justice, a lot of it focuses on, do you think you were treated fairly? Do you think you were treated justly? Do you think the first point of Friesen is to actually do it? And what's interesting to me is only 61% of you said flat out keep it. Now, we have 25% doing slight modification. Okay. But why is that component? Some of the answers already blend into one another, but can somebody just stand as a standalone box? Can we have this as a standalone box, or should it be merged into the first one? To do justice and to appear to be doing justice as one principle and responsibility, or can we bifurcate it?
I think they have to remain bifurcated because they're two separate
Right.
actions.
Yes. Who else?
Hold it,
yeah,
because we have people on the.
Yeah, sorry, we have stream friends.
The first is about substantive justice, and this is about procedural justice, and we view those as two different aspects of justice.
Right.
So I think they should remain separate and not part of the same thing, though I don't like the appearance of justice because that seems a little fake. Procedural justice is justice. So I think rewriting it to give more credit and weight to that concept would be good.
And I agree that keeping both of them. I think that the first one relates to the individuals, the litigants, the participants in the case, and the second one is the duty of the court to society in general, and as an entity of governance. And back again to I mentioned earlier, the rule of law is that it's the court one of its purposes is to be accountable to the public in general, and having the appearance of doing justice is incredibly important in that context.
Can I ask if anybody here, I'm going to get the other, did anybody here select keep with major modification and is brave enough to raise their hand? Yes.
I just don't, I kind of go with you. I don't like the wording of it. To me, I just think the word appearance of justice makes it look like we're fake, and well, as long as it looks like it's all right, then it's fine. But I think the wording needs to be restructured to make it feel more, I don't know what's the word I'm looking for, but I just don't like it the way it's worded. I think it needs it more, yes, perceived. There's just something icky about the way it's written, and so.
I'm trying to find a way to quantify icky, but I think we can. I'm there with you.
We can
We're there.
operationalize that.
We're trying to operationalize icky.
Yeah, we can measure anything.
Yeah.
And I also chose that it needed to be kept with major modifications. And just to tag on what I said before, the fact that it's kind of vague, that I interpreted one way and someone interpreted another, I interpreted as procedural justice and the feelings of fairness of individuals going through the system, that it's an individual justice, and sir, you interpret it as the public perception of the courts. To me, tells me it needs to be rewritten, and if both of those things are important, there should be a purpose for each of them, and it should be clear what they're addressing. Okay.
Not to interrupt, but after this, can we get the wings? I'm looking at the wings.
I agree with what you just said, Mandy, and I think it's doing individual justice and seeing that justice has been done. That's why we have public proceedings. That gets to the issue of public trust and confidence, that the whole theme of the conference.
Anybody on the wings?
Does that count as a wing?
On the wings. That's okay.
Is that?
Wing adjacent,
Can
yes.
you?
I'm sure there's some real estate term for like the specific location. Yeah.
So I had minor, slight, not major, but
Yeah.
to me, the appearance of justice, going back to the procedural piece, the procedure can be opaque for people that are not familiar with it, and that can lead to the public doubt. And so it's just vague enough that does it really apply to everybody? Is everyone going to, is there the appearance of justice for people that don't understand the process, for people that are at a reading level that don't? So just that, the public doubt that there is with it. could have more
Okay.
detail.
What else? Back. Thank you.
I know it does sound a little weird, the appearance of justice, the way we train new judges. You can't have the appearance of impropriety.
Yeah.
But I think the way that we demonstrate or the way justice appears is we have public courtrooms where people can come and see justice being done. In our limited jurisdiction courts, we follow very careful scripts that we say to all the people so that we're certain that they understand what's happening every step of the way. That's how justice can make an appearance. Yeah, the wording is not great, but I think it's also, the wording falls into what we traditionally train.
Jettison. This is the first time we've had some brave soul, 2%, it's probably one individual. Somebody said jettison this. If anybody's willing to fess up to it, great. If not, I'm going to offer up a rationale. Who cares what it looks like as long as it gets done? That is the gross utilitarian standard. I don't care that the boat doesn't look that great or that the car, slap a coat of paint on. I don't care what the appearance is. It gets me from point A to point B. I can go and I can do and I can receive justice. The fact that it happens to be behind a curtain or the fact that it happens to be, clunky junky doesn't matter. The point is the end result. Again, that's that raw utilitarian standard, right? So it's one person, whatever brave soul said that, there is a logic to it. Okay? There is a logic to that. And the other consideration is there is a historical logic to that. If you look at the history of courts, plural, the original concept going back to Alfred of Wessex said, and I'm pardoned for the sexist language, justice to every man's door. So what did that look like? That literally looked like hundreds of justices of the peace. So you didn't have a public, so if you had a dispute against your neighbor, you might literally be walking through the market and this individual may come up to you and say, again, justice, low level, justice of the peace type things. Well, he took my cabbage or he stole my cabbage. Fine, I find in favor of you. Justice may have got meted out right there. Did it look like it? No. They used to be called market judges. So the idea was we don't care. Alfred of Wessex, UK, English common law was less about the appearance and more about the act. You receive justice. The king's justice, it's lower level. We're talking about Magna Carta all the time. First of all, Magna Carta was addressed to the nobles, and the second one was, you're gonna get justice. I'm gonna send knights around on a circuit basis. Is it in public open? Maybe it is, maybe it's not. Is it in a tavern? Maybe it is, maybe it's not. But you're gonna get justice. Is there something to be said for the utilitarian standard? At a time of diminished resources and the idea of we'll just throw a bunch of judges at people. We'll throw judges at you. The logic is there. And thank you to the brave one person who said jettison.
Well,
yeah.
I don't know if this is the
No,
person.
I'm not the brave person.
Okay.
No. I would say that I think it's important to have a purpose that directly talks about the public trust and confidence in the courts. And I think this one is currently doing that. Especially, I think it's more important now than before. And so I think we've seen a lot of presentations about the lack of trust currently in the courts. And I think this one is, I think this is the time where we cannot jettison it, whether it's a minor modification or a major modification, which I would say appearance and perceived. I think that's a slight modification. But I do think it's important now more than ever that we continue to keep this.
So I was looking the other day, as I have, Pew has done research on this, Gallup has done research on this. The level of public trust and confidence in American the National Center does every year as part of its annual survey series. But Gallup and Pew had been looking back since the 1970s, basically post-Watergate. And over that time period, every single major American institution, which used to be posting in the 60s and 70s, is below the 66%, literally what used to be called the mom and apple pie with 66%. There's only 2 entities that even come close to that anymore. It's certainly not government. It used to be the military, which is at about 60% public trust and confidence, up from 50% after Vietnam, and small businesses, which is about 65%. If you ask people's public trust and confidence in small business, it's still at 65. Everything else has been on a downward slope for 45 years. So yeah, absolutely. What we need to do what we can to increase public trust and confidence in general, and obviously because of who we are and what we do, in the courts in particular. Yeah. But what I'm suggesting here, what I would suggest is we are fighting not just this fight, it's a fight against the wave, right? And it is cusping across every sector. Again, even the military has only gone up to, is no longer 66%. It's barely breaking 60. What else? Who else? So we got public trust and confidence. We got appearance of justice. Here's the one that has already been previously retold, but yeah. So, and again, it's kind of giving the game away because we have our modern iteration of this, but this was the original. So yeah, 50% of you said keep with slight modification. This is where if I could, I would wipe everybody's brains, MIBU, don't expose you to the Friesen, come at with this language, and then most of you probably, I would suspect, would come up with slight modification. 30% said just keep the language. Okay? 4% said jettison. We're up. We're starting to bail more things out. And 16 with major modification. Let's work it backwards. Why do we want to keep with major modification? What would be that major modification? How would you rewrite Friesen's original? Major rewrite. Let me ask you this. Coming at this from the perspective of a 6th to 8th grade English language competency, do you know what amicably means? Okay, so right off the bat, we got to do something with this, right? Fair, impartial. There was a survey done years and years ago by a group called Justice at Stake. One of the things they did survey data on was this: do you believe in judicial independence? Guess what voters don't like? Judicial independence. Because you're not going to be independent from me. Crash down. But then you say, hey, do you want courts that are fair and impartial? Yes, everybody wants that. Judicial independence is the means to that end, but people really cared about the end. So amicably, or at least without a fight, again, that gets kind of a little old school. But again, I understand, and I think I follow the logic of major modification. Yes?
Yeah, that's where I was kind of focusing, because honestly, I don't care if the two people like each other after it's all over with. They
right.
just had a chance to present their arguments and be heard.
Yeah. That was always that was a fear that I know had previously happened was, we don't want to measure people's perception of the courts because 50% of people are going to hate us and the other 25% don't think they got enough civil litigants. Oh, I didn't get my everything. So automatically you have No, the research we have 20 years to look back. No, a lot of people are okay with losing if they think that they lost fair and square, amicably. Again, I don't want to use that word. Again, amicably, SAT word. Keep. Who here wants to just keep it? Again, there's arguments in favor of everything. I'm not trying to dissuade anybody or persuade anybody. Who wants to just flat keep it? 30% of you do, yes. Yes, you. I'm sorry, yes, red jacket. Oh, no, here, we got there, and then we're going to get the microphone. Yeah. You want to keep it?
Yeah, though I'm immediately persuaded by the slight modification with maybe updated language. But the key, I think, particularly as we enter an era of likely more frequent political violence, I think this piece is especially important to emphasize that courts exist to resolve disputes essentially as peacefully as possible. So that was my thinking in the keep vote.
Okay. Who else likes keep? Keep.
Yeah. So going back to pre-Magna Carta of how we resolve disputes, I think it's important to remember that history.
Yeah.
And that the alternative is people battling it out, and bloodlust and revenge and vengeance.
Right.
We don't do that anymore, and it actually distinguishes our society from others that may still engage in that. And so I think it's important that we recognize that's the alternative.
Okay. 4% of you said jettison. So that means it's about 2 people. So just jettison this. We don't need to have a way to reduce. One of the purposes and responsibilities is not to resolve disputes amicably, or at least without a fight. Who here wants to own, again, I'm not asking, if you don't, that's fine. Whoever wants to own up to jettison this? Because I'll make you want to jettison, what?
For me, it just felt a little outdated and limiting. I think courts do a lot more than just resolve disputes now. I really see them as social service agencies. And I think when we look at it as, here's a place to come solve an argument so you don't kill one another on the street, I think it sets a tone, it kind of pours into some of those myths or misunderstanding about what the court does. So
Right.
I think we could get rid of it and come up with a better replacement.
Yeah. Yeah. And sneak preview, that's kind of what Batty and Flango were saying. Flango in particular were saying, we got to reword this. We're not, again, political violence notwithstanding, we're not, again, 1,000-year logic to that, but we're usually not at the point of personal vengeance. Or at least that's kind of the edge case. Anybody else on this question? We are working the technical aspects right now. Ooh, something just blinked. So.
There's one more.
Oh, whereabouts? Oh, hi.
I still like the keep after hearing everyone, just because just living in the courtroom, which we don't have a lot of cases, but I think amicably is a good word.
Okay.
Because the small claims I see and just dissolutions, there's a lot of truth to that amicably about how people feel when they leave the courtroom.
Yeah.
And I agree with the second part as well. Just a lot of unrest these days of bringing violence on decisions, and so that's my thought.
Small claims in some states used to be called reconciliation court or conciliatory court. We're reconciling two people towards each other. We don't need the formalities of juries and judges and rules of procedure. Right, it's amicable resolution. Again, we're going to have the guy walking through the market and he's going to resolve the case right in front of you and everybody walks away happy and with a cabbage, I would hope. Or at least payment for cabbage. But yeah, again, it's friendship courts. So, thank you to our technology people. A formal recognition of legal status. 56% said keep, 39% said keep with slight modification. Keepers? Anybody want to own to the keeping? Yeah? Yeah?
It seems just fine that we're the official keeper of record.
Yeah.
So there's no reason to change it.
Borrowing my Latin, res ipsa loquitur, the thing speaks for itself. Courts have records, records have, and records are actions of courts, and so therefore it becomes a truism, right? Okay, follow the logic. Yeah.
Can I advocate for keep with slight modification?
Yeah, that's gonna be next.
I think we have to be accessible, and I think what I would add there is a formal, accessible record of legal status, because I feel like there's a lot of obfuscation that could go on that we have the ability to do that needs to be not part of our values and purposes.
Anybody else? We got somebody who jettisoned, but I'll get to that in a second. Yeah.
In addition to what was just said, I would add something about timeliness and accuracy and protection, especially in the modern age of protecting records and ensuring that they are accurate and maintained timely.
Good. What else? Anybody? Green sweater?
My modification, I don't like the wording legal status. I think that means something different to us all today. And if we're talking about keeping a record or maintaining knowledge of what's happened in the past, I think we could say that a little differently. To me, when I read this, and I think probably others, it probably hits a little bit different in our climate these days.
Who else? Anybody want to take the 2% for heavy modification or 2% for jettison? Because I'll make arguments for jettison. Yeah.
I'm not responding to jettisoning.
That's good.
Okay. So I liked the point that was made about a more accessible record. It occurs to me that, in an era where anyone can use technology to create a record of the proceeding, the historical stance of courts to restrict the right of parties to do that, coupled with the fact that in some states we're required to use court reporters but don't have court reporters, is creating this real tension. So I think we need to address this question of, sure, the court can still maintain the official record, but should we keep restricting parties from making a record if we're not providing them with one?
Anybody else want to take any of them? Because then I'll be the bad guy and take jettison again. Limited jurisdiction courts in which there is no formal official rules of practice and procedure are one step above brawls in the street, and therefore should not be afforded the courtesy and respect of being called a record. It's literally called a court not of record. There's a reason why your general jurisdiction courts are called courts of record, because the perception, again, anybody who works in a limited jurisdiction court, I love you, I'm not trying to disrespect you, I'm trying to explain your history, which is, nope, this is just 2 steps above a brawl in the street. You get some rando, possibly not lawyer, judge in a bench, possibly in a robe. My favorite is Alaska used to say you couldn't hold court in a bar, which, again, justice administered locally. It also means that at one point or another they did have justice in a bar. Midwest, Western states, the bar was the only building you had. But the idea behind this is formal record isn't really necessary for a lot of what courts do. You maybe need to have access to it eventually, right, on appeal, but for a lot of these things, you don't need to have a formal record. And we're not doing it anyway, depending on how, I think the gentleman in the back, depending on how you define record. Do you mean a bunch of documents and sheafs of paper? Do you mean a verbalized transcription? What do you mean by record? Not arguing for it, not arguing against it. I'm just providing a relatively sequenced jettison argument. And finally, in the original Friesen 5, protect individuals from the arbitrary use of power. 67% said keep, 25% keep with slight modification, and 8%, I'm trying to see what the 8% is. 8% said heavy. Nobody wants to jettison the arbitrary use of power. All right. I'm sorry, I'm supposed to be neutral, Bill. Hold tight. So let's work it backwards. Who wants to heavily modify it, and what would you modify it to? Yep.
Maybe heavily, maybe not.
I'm not sure what constitutes heavy. Having read Batty and Flango, I know that the direction that they went in is that we want to avoid the abuse of power by anyone. And so they pointed to, prevent corporations or individuals from exerting unfair power over anyone in a manner outside the law. So that you can say that whether that's a modification that's minor or large, I don't know. The general principle, I think, is the same.
Okay. Keep with slight versus keep with heavy, right? I mean, that's eye beholder. Yeah. Keep. Got a lot of keepers. Anybody want to be brave enough to explain why you want to keep courts there to avoid the arbitrary use of power? Here's my question. Again, not to take the jettison side, but I'll take it for a moment. Protect individuals from the arbitrary use of government power. Who watches the watchmen? Can courts not execute on the arbitrary use of power themselves? So what's the feedback loop there? It's within, now we get into the larger context of checks and balances, and we get not just appeals, but checks and balances and all these other things. So there's an argument to say that this creates an internal inconsistency. Courts are governmental power. Courts can be arbitrary. Therefore, courts can do. Is the purpose and responsibility of courts potentially have a built-in flaw, or this one? Yeah. One more, and then we're going to get into the next round, which is the Criminal 3, which, again, another great band name.
With the checks and balances, that's why you have the legislature. So that would be the balance to the courts. They write the laws, and we interpret and enforce them. So I do think it is necessary.
Yeah. Okay. All right. So I'm going to put up on the screen. I'm going to try to. Thank you, my tech friends who are trying to help us here. The next one is going to be, hold on. Let me go to the next one. If we get this up, I want everybody to take a QR code again. This is Friesen's Criminal 3, which was the 3 that came afterwards, after the original 1981, that are currently part and parcel of our modern purposes and responsibility of courts. We're going to go, we have about 15 minutes left, so we got about 3 minutes on each, and then we'll do one last exercise. So take a moment. And our online friends, if you could look at the QR code, or if you could go to the link, which is in the PDF, that should be able to provide you the opportunity to vote and weigh in on this the Criminal 3. Okay. Has everybody had an opportunity to vote? Fantastic. All right. I'll pull up the results here. Deter criminal behavior. 84% have some version of keep it around. Who wants to keep it? Majority. Anybody? Deter criminal behavior. Anybody want to make the case for keeping that as a purpose and responsibility of courts? Now we're down to 50. Somebody got scared. Are courts there to deter? Okay. What about rehabilitate? Yeah. Yeah. What about detect? So we have deter criminal behavior. How does it deter? Why should it deter? Let me try this. Why should it deter criminal behavior? That's what the executive's for. That's law enforcement, as we understand the concept today.
I suppose it has to do with if you have something to lose, right? Which a lot of the research shows, like if you're employed, some of these things feel a little bit harsher than if someone weren't employed, like affects risk factors and such. So I suppose if you're going to have the law, you have to have a way to enforce the law, and there has to be some sort of consequence then for violation. And so that would be the deterrent, right? Of you're getting in trouble and you might lose something that you value,
right,
whether it's your freedom or finances or social status.
Let me just try one thing quite quickly.
Bill, the individual on the call or in the chat said yes, as far as deterring and having that statement deter. Do you want to do that?
Yep.
Swift and certain justice is a great deter of crime.
Swift and certain. Okay. Yeah.
These three have always been problematic to me because it deals with issues of which branch has the power, which you've alluded to with the questions about rehabilitation and things of that nature. But there are many different aspects of criminal justice theory as to what you do with the crime. You know, there's deterrence, there's punishment, and there are other motivations. And you have to ask yourself here, is the court simply carrying out the legislature's decision about what is to be done when a finding of a crime has been carried out? And then what is the purpose of the sentence? Is it to rehabilitate? Is it to deter? Is it to punish, etc.? Yeah. And so what is the judiciary's role? Is it the one that's actually doing the deterring, or is it the legislature, or isn't carrying it out? Is it the executive branch that is doing it? So it gets a little nebulous as to exactly what the court's role here is, aside from just finding that the law has been broken and imposing whatever the sentence is that's prescribed by law.
It's that formal record, yeah. Mandy, and then a gentleman in the blue shirt. Sorry.
Then Mandy.
I'm going to talk about jettisoning, so.
Yeah.
Ooh.
So I'm probably in between what she may talk about and what he just mentioned. I've always struggled with all three of these. I mean, to his points, if you study punishment, there are 4 purposes of punishment. Deterrence is one of them. Incapacitation, rehabilitation, and restitution are the other 3. So deterrence doesn't occur without court involvement, but I don't think that means that it's the court's purpose to deter. And the biggest reason I struggle with all 3 is if you espouse to court professionals, to society, that it is our purpose, then it compromises our neutrality and our ability to act as an unbiased entity to administer justice. If a judge thinks that it is their job to rehabilitate someone, they are going to rule, or deter criminal behavior, they're going to rule differently than if they think their job is just to administer justice based on the law. And I think that is really problematic.
Okay. And then Mandy, and then green sweater? Or are you just raising your hand? Let me get you a second.
That's okay. Okay. So I actually said jettison all 3 of these for these reasons, because I feel like this is a taking over executive power, and that's not the court's job. And so the court is not there to deter criminal behavior. The court is there when the state brings a case against someone. The state, when you commit a crime, you don't commit it against a person, you commit it against the state. And so the state brings a case and says, hey, this person has violated the social contract, and so we have this evidence, and we would like you to make a decision about whether or not they did this. And that is the court's job, is to look at the law and that the legislature passed and determine if the executive has made their case. The court is not there to prevent people from punching each other. I mean, other than to provide a neutral, fair, impartial, whatever. The court is not there to deter criminal behavior. That is the job of the executive. And I think that it's just, it would be like, I think you can cover some of these things like swift justice. That's part of substantive and procedural justice. You don't have to have something separate for that. And so I think a lot of things we think about with criminal justice are covered by other purposes. And it would be like saying that the court is there to deter people from not following contracts, or the court is there to deter people from not paying child support. Well, no, that is whatever agency does that thing. And the court is just there to apply the law to the case and make decisions. And so I don't understand why crime is its own separate thing when the court, all the other purposes cover all the other kind of cases or case types that come to court. So yes, I have never liked these.
I think what is interesting, though, in the context of all of this is that there are statutes and legislation that tell judges for mitigating factors, you have to look at deterrability, right? And how likely is this person to rehabilitate? What's the least restrictive supervision or release guidelines we can put on someone? Part of when judges make their sentencing decisions, they say, I am doing this in order to deter other people from doing these things. And part of that is statutory. So there's this intersection of what the law says judges have to consider when they are making these fair and impartial decisions. And so that just got my wheels turning as we think about that, right? Like, we want to think that it's neutral and fair, but there's bigger biases maybe for reasons legislation was created that are controlling some of those decisions.
Hey, Bill,
So
we
I'm-
have 7
yeah.
minutes.
So I'm gonna actually expedite this a little bit. I dislike disengaging dialogue, but I have to. Forgive me. I'm standing between you and lunch, and that's a very dangerous place to be. So I did advance the slide to rehabilitate persons convicted of crime. Again, 40% keep, 38% keep with slight modification. The conversation we just had blurred the distinctions between these two questions. As Kent pointed out, gentleman in the blue shirt pointed out, Mandy pointed out, all of you pointed out, this is just a blurry mess, these two. And then finally, the last one was separate some convicted people from society. That's pretty overwhelming. That is 55% said keep with slight modification. And again, I think some of the things you alluded to was some of the conversations we had. And again, these all came in together at the same time. And I think we're of their era and of their time. Okay. So the one last thing we're going to do is now you all get to be authors. And so there's one last slide, which is if everybody can zoom QR code this, and friends on streaming, there's a link. And this is going to be, what would you add? We've already talked about subtraction. I think there's a couple jettisons. There's some there's some light modifications, there's some heavy modifications. So Frankel thought reformulate. I go back to Batty. I go back to trial court performance standards. Adherence to the state and local constitutions is a purpose and responsibility of courts. Okay. So there's not a set, but what would you add? This is an addition to what exists, whether you will call it the Friesen 8, the Friesen 5, the Criminal 3, the Fantastic 4, whatever. And this, because of the glories of modern technology, is going to be more of a word cloud. So we've got, I'll remove this arrow for the second. We've got definitions and expectations, rehabilitation needs, needs of the community, data, equality, neutral branch, sky high, law for all persons, experiences have different, so we've got access. Access is coming big, law. Okay, by the way, for those of you, again, this is going to probably turn into a court manager article. Nobody will be identified, this is all anonymous, but it's important. You, again, I come back to the original point. I come at this from an academic perspective, alas and alack. You are the practitioners. You're the ones telling the practice that this is what we need to add or at least consider. And what you're saying here is, in very, very tiny font, because Microsoft is not friendly, is access to justice, persons, data, proper. Again, there's proper, right? We can have, court record, proper access to court records. Think about how many people have evictions on their records now and can't get an apartment. We've got a formal access to we have the formal status. You were evicted. There are ramifications to that. So maybe it's not access, maybe it's proper access. Expectations around justice, data. My goodness, data in courts? Inconceivable. Somewhere Diane Robinson is screaming. Expectations, and that gets into that public trust and confidence. That gets into what do you expect to have happen? What do you want to have happen? Okay. So, as we wrap up, again, in 3 minutes between you and lunch, I want to begin by saying, first of all, thank you for the gift of your time. This is valuable. I hope it was. It certainly was for me. I hope it was for you. I've tried to limit the amount of my discussions and dialogue and diatribes, so I'm going to ask you to do 3 things. 1, because I'd like to have it done, and 2, because, again, I refer back to Jude wagging his finger at me. Number 1, go into your app, complete that SRT question, rate the event. I am not proud. 5s are wonderful. Friesen 5. Interact, engage, continue this dialogue. Okay? Join us, follow us, share, comment. Comment sections don't have to be scary. They just normally are. But keep this dialogue happening. I come back to a point I originally made. I have the utmost respect for Ernie Friesen and the first generation of court managers, court management. What it meant to try to take a stab at a big question that has been perplexing us since Aristotle in politics. What is the purpose of a judicial system, a court system? That notion of this is where justice happens. There's a very architecture they'd look at in Greece. There'd be these white circle of stones, and it was like, is this a religious area where an altar was, or is this where justice was handled in a council? And the answer for both was yes. It is a secular, to borrow a phrase, a secular religion. It is who we are and what we do as a nation, as a culture, as a society. The purpose and responsibility of courts is how we manifest that. Friesen made his stab at it. TCPS made its stab at it. Flango and Batty. Here's what I'd love to have happen. Make your stab at it. Write it down. Put it in Court Manager. Or file it away in your head and say, this is why I'm here. If that's all you take away from this is why I'm here and this is what I'm doing, then I feel blessed. As long as you sign up. Thank you for the gift of your time.